Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
This is the next search on February 28, 2020, 7:44 p.m. How, does the FBI find people, and people is misspelled P-E-O-O-P-O?
Because he's the guy.
Did the defendant find out how the FBI finds people in this case? Oh, she found out.
I object.
What more do you need to see?
All right, that should be a little bit better. At least you should be able to hear me. Is that too loud? Check 1, 2, test. It's like booming in my ears. Test 1, 2, test. All right. Oh, but now I don't have any. I didn't think this one through fast enough. Music is loud. It's hard to hear me. Standing room only. I don't have chat today, which means I have to change a plug. I don't know if I can put chat on screen today. I know that's terrible because I really like to do that. But let's see. We have camera 1, camera 2, camera 3 is blank. Camera 4, camera 5. Okay, we've got 5 cameras, but we don't have chat. If I get rid of let's do a little vote. Yes or no, should I get rid of our replay machine today, our instant replay machine, and instead replace it with chat? Is it a yes? Would you rather have chat or instant replay? Because I can't guarantee anything interesting is going to be on the replay. Let me do a quick check here because we have. Can we please watch a trial today, Cecilina? Yeah. Well, we'll watch court. That's what we do, but I'm not sure if we'll have a full trial. Do you need to go in there somewhere? Okay, go ahead. Let's pull up Judge Middleton really quickly and see if we can get him with audio.
2 pre-trials.
Can you guys hear this audio?
And then we have pre-exam conferences, and we may have some prelims this afternoon. So,
okay.
Yeah, let's hope
so we're making
nothing
progress.
Bad happens anywhere. We won't know who won until sometime later this week, I suspect. We do have one local race.
He's still talking politics.
There's a probate judge race.
He's talking politics.
Judge Tomlinson, Kevin Kane, who is a man that works in our probate court, and Kelly Ward, a young woman who works in the Van Buren County Probate and Family Court. So good luck to both of them. They both worked very hard.
One of them's going to lose.
And I'm sure they're glad this is going to be over. All right. Judges do vote. We can't endorse any candidates other than judicial candidates. So we can't have a yard sign for a Republican or a Democrat. And they say, well, if your wife has one, have her put it in her side of the yard. But in Michigan, judges are not allowed to endorse a partisan candidate.
Okay, so judges are pickles, not politics.
All right. Good morning to everybody from Sturgis to Australia and our guests that are here. Let's go live. We'll bring Mr. Rognus in. I don't think we have a customer.
What's he doing this morning?
Thank you all for saying good morning. It's probably a hectic day where you are.
It is.
And
We're gonna do
whatever
birthdays.
happens, we will abide by it because that's how it works.
Okay, I'm looking for birthdays. Do I see any? I do not. There we go. All right, we're gonna pause. We're gonna pause just for a minute on the judge, who's still doing political talk apparently, and do a little birthday celebration instead. Birthdays for Sweet and Salty, Nick, and Schmoopy, all celebrating their special day today. Thank you, Sharon, for putting that together for us. So let's all stand up, take a deep breath, shoulders back, project your voice to the back of the room. Blend your voice with your neighbors. Warm up with me, if you will. La 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 la. There we go. It's going to be a good one. We're going to sing the Sweet and Salty Nick and Schmoopy. Happy birthday to you. Happy birthday to you. Happy birthday, Sweet and Salty Nick and Schmoopy. Happy birthday to you. To everyone who's celebrating their birthday, especially Sweet and Salty Nick and Schmoopy, happy birthday. It's wonderful to have you here with us. We're grateful you made it here and that this is your special day and that we get to celebrate with you. There are a million places you could be, a million people you could be here celebrating with, but you've chosen to be here with us. I was just watching the lawyer was trying to put his tie on camera, and I think it's a clip-on, so that's all. We're excited. Start off your special day with free pancakes at Denny's, Waffle House, Village Inn, IHOP, Andy's Bar and Grill. I'm just saying, Andy's Bar and Grill, they serve pancakes. I found out just the other day. They serve pancakes. So you have to go all the way to North Carolina to find that one. But find a place that will give you free pancakes on your birthday, because other than being sung to, that is the second best way to start your day. Have a happy birthday. Hopefully we can make your day a little more specialer. Thank you for celebrating with us. All right, we're going to keep it going just for a minute because I have to change the plug to get rid of replay so that you can have chat. Because I had it on my screen. You can see it over here, but you can't see it on your screen until I change a plug. Although tomorrow I won't have to do that because we'll have this camera replaced sometime tomorrow. This one right here, that one is going to be replaced sometime tomorrow, and it will wire directly in through SDI, which is a huge upgrade. I'm super excited about it. All right, so give me a minute. We're going to jump to court with Judge Middleton and see what's happening with him and Mr. Rajness. Excuse me. I'm giving him a time to finish up with. Makes a good point. Drum solo. Here we go. There we go. All right, that was a good point, wasn't it? All right, let's jump back to Judge Middleton while I work on the cables.
She's
for
not
just
in
a
my
second.
queue. And then she has a felony case this morning, so let's take a look. One 907. Yeah, it was authorized on a ticket by Seth Chittister. And why he wrote it under state statute is a mystery, but it was authorized.
Was there a weird sound?
And she has been in custody at this point for $18 days. She had two separate trespass, 241855.
That might have been while I was just plugging it in.
241907. Let's look at the other one.
While I was plugging it in, it was defaulting back to a loop, so it might have made some weird echoes.
That's written under ordinance.
I wish I heard the gong.
I think maybe the officer just checked the wrong box.
Is Kim around?
Someplace. Now that one is set for I don't know what's going on with that one.
If it was agreeable to.
Yeah, she has a pretrial in both cases this morning. So she could plead to the city case and dismiss the county case, I guess.
Yeah, that's fine with me.
All right.
And I have no objection to time served either.
And the other pretrial is Austin Shaw, which is an ordinance case. So I don't have anything else for you this morning, Andrew.
Okay. No, I mean, if she'll plead to the Three Rivers case, we'll dismiss the state case. And like I indicated, I have no objection to time served, Your Honor.
All right. Thank you very much.
Thank you.
All right. Well, you can have your cup of coffee and a donut, and I'll see you later.
Okay, good enough.
Judge just checking in.
Have we seen Tim George?
Yes, I have. You want me to go find him?
Please. He's probably busy with his PECs.
Okay, so we have chat back. It's almost like we're back to normal here.
Problem is I don't have that other case.
I can still record things and do replay like at a later time. I just can't.
241855.
Donuts. Love donuts. Melissa, good to have you here. Hope you and yours are doing great today. Didn't see Matthew, but if he's here, good morning.
Hi. I have a pretrial this morning on Yasmin Campbell. She's back in the lockup. I have before me 241907, but the other ordinance file 241855OM also shows it's set for a pretrial this morning. All right, thank you, because I think she's going to probably plead to that one and dismiss the other one. Yes, 241855OM. All right, thank you. Bye. All right, we're in hurry up and wait mode.
That's where I live.
Larry, she has multiple trespasses over the last while.
Okay, try the commands again, see if that's working now.
And she has 2 pending right now. Andrew has offered to dismiss his and no objection to time served if she pleads to the Three Rivers one. She also has a pre-exam with Paul Gibson representing her.
There we go.
He's talking where this clients will be in shortly. He was talking to Dave.
Okay. Do you have anybody else in the back?
At this moment, no, because we could not bring over, I think it was Conway.
Yeah, we won't bring her over. We'll do her by Zoom. Don't bring her, let them know we're not going to bring her over.
107. Let the jail know that Conway will be over Zoom. Those are the only 2 I have in back.
She is still doing very poorly, according to the Forensic Center. All right, well, if we get Mr. George, we can do Miss Campbell. Thank you. (11:05) at 8:30. It's on here. And we're looking for someone named Austin Shaw.
He's in the back.
Oh, is he?
Yes.
He's also a Tim George. How long has he been in jail?
I think he said about a week, but then he says
Good
he's
morning,
gonna
Mr.
probably go to
George.
another county.
You got your hands full this morning. Thank you. We've got Yasmin Campbell back in the back. Andrew would offer to dismiss his trespass if she pleads to your trespass. She's been in custody for 18 days. We have a young man named Austin Shaw who is a pretrial. He's in custody. He has a felony, failed to appear, and he is allowing another to violate the motor vehicle code. He's been in jail for 8 days. So why don't we bring Ms. Campbell and Mr. Shaw in? Or would you rather do them one at a time?
Big Mike, thank
Let's
you.
do Ms. Campbell first.
Appreciate the advice on the hard drive. I got it. It's working great. Wish I could
All right,
show
we
you.
have been on the record and on the live feed. We haven't been doing anything but spinning our wheels. You've also got a number of PECs this morning. Thomas Mack, our only arraignment, he didn't show up.
I haven't got anything on the burner phone since Friday. Like it's not receiving anything.
The blower is
There we
on
go.
today.
Never mind. It's
Sometimes it's deadly quiet in here, but the air handler is. Good morning, Ms. Campbell.
Good morning, Judge. How are you?
I haven't seen you face to face in a while. I've seen you over the video hookup, but good morning to you.
Good morning to you.
You got 2 trespass cases we're going to address here. And then we're going to deal with your other case in a little bit. But it's alleged that on October 21st that you did trespass in the city of Three Rivers. That's a violation of Three Rivers City Ordinance, punishable by up to 90 days in jail and a fine of up to $500 under ordinance. Under state statute, it's alleged that you did trespass someplace on October 18th. That's a misdemeanor, punishable by up to a $50 fine and up to 90 days in jail, up to 30 days in jail. State trespass is different than the ordinance trespass. You've been in custody now for 18 days. Mr. Rognes, the county prosecutor, offered to just dismiss his charge if you plead to the Three Rivers charge and recommend that I just give you time served, which is 18 days, credit 18 days on the trespass charge. Do you understand?
Yeah.
Now, the gentleman next to you is Mr. Larry Westcomb. He's from the public defender's office, and he's here just to make sure that I'm doing things correctly. Are you willing to plead to the second trespass if they dismiss the first one?
Yes, sir.
All right, we've been through this before, but did anybody promise you anything to get you to plead to this
No, Your Honor.
or threaten you?
No.
Do you understand that if you plead to these charges, you're giving up your right to have a trial in front of a judge or jury? There will be no trial. Understand?
Yes. Can I ask a question, Your Honor?
Yes, sir.
Yes, ma'am.
Oh,
Sorry,
I'm
Your
sorry.
Honor.
I'm sorry.
Sorry.
Yes, ma'am. It is correct.
Oops.
I don't know what I was thinking about. Yes, yes, Ms. Campbell, you can ask me a question.
Okay. My other case, I'm not gonna, after these 2 trespasses, I'll leave out and then I'm done.
Well, we're going to have Mr. Gibson see you on your other case while you're here. So I'm not
Okay.
sure what we're doing with that one yet because I haven't seen him yet.
Can I get a bond reduction?
Well, we'll talk about that when he gets here.
Yes, sir.
But this will take care of this trespass.
Okay.
All right. So, you understand that if you pleaded that charge, you'd be giving up your right to have a trial. You'd have a right to testify. You'd have a right to have an attorney. You'd have a right to have witnesses for or against you subpoenaed to come to court. They could not use your silence against you if you didn't testify, and you have the right to be presumed innocent.
Yes, sir.
Understand?
Yes, sir.
All right, let's take a look and figure out which one this was.
Is anyone covering
All right, this one
the Colleton
was
County trial? The husband that set his wife on fire?
503 South Main near 6th Street. I guess that must be Shellmart.
That's Shellmart.
All right.
Court TV is.
They had told you not to come there and you came back?
Yeah, a certain amount of time had passed and I needed to get a lottery ticket, and that was the closest store. So I tried it. I don't know how long trespasses are for. Like, I thought, like,
just your life.
It was less than a year or something.
I think
and I thought that maybe I misunderstand when you say dismiss. When you say dismiss, I think that they're no longer valid, but that's not true. I guess they're still valid. So my interpretation of dismissing and pleading to one is totally different than what I was.
All right, yeah, they don't want you there. And even though the case may have been dismissed, the trespass notice remains.
Yeah.
So I'm going to give you 18 days jail, credit 18 days. And I'm going to waive the fine. I'm going to make it concurrent with your other case. And I'm waiting for Mr. Gibson. I'm always waiting for Mr. Gibson. But it is, to his credit, only 8:31.
He's here, Your Honor.
Yes. All right. Why don't you go ahead and take Miss Campbell back? Don't leave her, but take her back to the back. And when Mr. Gibson comes, we'll find out what we're going to do in the other case.
You want Mr. Shaw?
Yes, please.
Oh, man, it's terrible. It has
All right,
SA
Miss
in it.
Campbell. I'll see you probably in a little bit.
It's a tough one.
This guy is allowing another to violate the motor vehicle code, and he's got 8 days in jail. I'm not sure what his circuit court circumstance is. Luke, the magistrate, is back today, so I won't be doing jail and bail arraignments. But there was only one.
Life back to normal next week. That's awesome. Congratulations on 12 months day. Let me just read just a synopsis that Court TV put out about this. We're talking about the burned alive murder trial, South Carolina, Colleton County. That in January 16th, police say the husband hit her with personal weapons on the butt of a firearm or shotgun, breaking the weapon over her hip. The next day, police say he lit his wife on fire inside their home in an attempt to kill her. January 17th, Terry's daughter, the daughter, says that the mom told the husband that she was going to leave, and it started a fight. The argument turned physical, that a violent rape was involved before throwing a rag or a shirt lit on fire at her, and that when she tried to throw it away, he would throw it back until she caught fire before finally stepping on her hand and crushing it. It's brutal. It is brutal. You don't want to hear these facts. Sorry, they're terrible. Okay, so we'll look at that. Let me. I don't want that case. Judge McBurney has a trial going on as well. His audio is terrible. It's hard to fix. Silly Pick, congratulations, 5 months. Congratulations. Your courthouse is about to change color, so get ready for that. We do have some Cedric Simpson live. Let's see if we can take that, see where he's at.
How much are you claiming you overpaid?
September of 2022, my rent was $2,120. Starting in January, they increased it to $4,081. That's $1,961 per month times 12 equals $23,530 in overcharge.
Can I ask a question then? Why'd you pay it?
It's a term, it's automatically charged to my account, and I have a conservator. That's where I got this report on monthly payments.
All right. So you have a conservator?
Yes.
You currently have a conservator?
Yes. He's negotiating my new residency as we speak.
Okay, so let me ask you this. Did your conservator say anything to you about the amount of rent you're being charged?
Well, 3 months after the fact that they started charging me and called me and said, do you know that they doubled your rent? And I said, no, but I'll look into it. And he said he didn't feel it was right. And he wished me well in this negotiation that's about to happen.
You have a position on his claim, other than you don't owe him anything.
Yes, and I'm happy to fill in a few of the gaps in the facts here, Judge. So, Mr. Chatain's lease is a 30-day month-to-month lease, and it states in the lease that upon providing written notice, American House can change the rent. That's what they did here. They provided him written notice that they were increasing his rent. And the reason that they increased his rent, he's correct. His apartment is meant to be a shared unit with a roommate. And because of the condition of the apartment, they were not able to rent it to another tenant. They had given him warnings about this and saying, can't rent this to somebody else because of the condition of the apartment. Then they provided him with a notice and they said, if you don't get the apartment in condition where we can rent it to somebody else, we're going to raise your rent effective in January. That's what they did. They were contacted by the conservator after the rent went up, and they explained to the conservator, here's the situation. We've increased his rent because we can't rent the bedroom to somebody else. And the conservator said, okay, I understand. And didn't stop the ACH payments, continued to allow the money to be drawn. After about a year, Mr. Chatain got the apartment in the condition that American House decided it was satisfactory to try to rent it to somebody else, and they reduced his rent back to the original amount.
Because they were able to rent.
They still weren't able to rent the room to somebody else, but they had asked him in writing, we want you to do A, B, C, and D to get the apartment in a condition where we believe we would be able to rent it. Because of other issues, they were not still able to rent the apartment to him, but they followed through with their side of the agreement and reduced his rent. Yeah.
Is that correct?
No.
Okay. Of course not. So what part of that's not the case?
It was not a question of them increasing the rent as in a normal annual increase in rent. They changed the terms of the contract from me living in a 2-bedroom, 2-occupant suite to saying you're now renting the whole
Mr.
suite.
Chatain, yes, but that was their claim, wasn't it?
Well, they never provided
Well,
me.
hold on.
I'm sorry.
That was their claim. It was supposed to be a 2-occupant suite.
Right.
Okay.
I had 4 roommates before this over the last 10 years.
Okay.
So, and they've all complimented me on how nice it looks. It boiled down, in my opinion, it boiled down to the question that I had masks from all over the world on the walls, and I had a very demure nude. And none of my roommates.
Demure what?
Nude. N-U-D-E, nude, naked woman.
Okay, I'm presuming,
Yes, and they
presuming a statue.
I'm sorry.
Was it a statue of a nude woman or
No,
actual nude woman?
Just a painting.
Okay, all right, thank you. Go ahead.
Not an actual.
Well, they demanded more room, and they made me throw away my leather sleeper sofa because they wanted more room in the room. No one had ever complained about this.
Mr. Chastain.
Yes.
You would agree that there was supposed to be another occupant in the room?
Absolutely. They
okay.
will admit that I asked for a roommate.
Okay, but hold on. They then did they send you information saying they couldn't lease the other room?
No.
So they never sent you anything?
I have included everything.
I didn't ask you what you included. Did they send you some notification regarding what you needed to do so they could rent the other portion?
No.
Never.
Nothing. After repeated requests.
So if I set this for trial and they have that, you might admit that you don't have a claim.
Of course. But they've never provided it in the last 2 years.
Okay, so
it doesn't exist.
So at some point, Mr. Chastain, your rent goes back down.
Right.
Right? So why did it go back down?
Because I threatened to sue them for their mistreatment.
So they just lowered your rent?
Well, they made me do a number of things because they were going to increase already increased rent another 10%.
So what were those things they were asking you to do?
They made me remove most of the artwork from the living space. They made me clean off my own dining room table where I had a sculpture. They made me throw out my couch.
But hold on, this dining room table. The dining room table would have been shared by the dining room area would have been shared by the occupant.
Everything that's in the apartment is shared.
So they asked
silverware, you name it.
Okay, so they asked you to remove
all the stuff that was on the
dining room table, so that if there was somebody else there, they could use the dining room table.
And the prior roommate did use it instead of going down to the dining room.
Okay. So what else did they ask you to do?
They asked me to remove half of the material in the linen closet, which was easily done. They made me move.
So that the other tenant, if they were there, could have space.
Right.
Okay.
They made me remove half of the material that was in the shared closet. It had never been a problem before. It had accumulated for 12 years, 10 years back then. And I was able to do it, but I gave away, I would guess, thousands of dollars worth of stuff. Yes.
Have you listened to what you've said to me?
You asked me to go on.
No, I know, but have you listened to what you've been telling?
They out of the blue produced an article that said,
Mr. Chastain.
Yes.
How did you get notification that they needed you to do these things?
I never got notification without asking for something in writing. It shows that these friendship suites exist and what the requirements are. They gave me a list of things that were particular to my room, and it's not a general policy.
Mr. Chastain.
Yes. I'm sorry, if I speak loud, it's because I've got these.
I understand. How did you know what to do?
After corporate officers came out and said, this isn't a friendship suite, and I asked why, and they said it looks lived in. That's all they
So
said.
let me ask you this. When they talked about, let's say, the dining room table.
Yeah.
Did they tell you why you needed to clean off the dining room table?
Well, half the table was covered with my current mail, and they wanted everything off the table.
Mr. Chastain.
I'm sorry.
You need to answer my question. Did they tell you why you needed to clean off the table?
In case my roommate wanted to eat.
Yeah.
And I did.
Okay. But before that wasn't the case, right?
Not after my last roommate left. I told you.
Okay. All right. So let me ask you this.
All right.
Did they tell you why they wanted you to empty out half of the closet?
Because it belongs to the other person. My potential roommate. And that was very
difficult. Mr. Chastain.
Yes.
If you're paying, let's say 2120 for a space that would, if the landlord could use it, would cover twice that amount. Right?
I didn't quite catch that.
They had another person in there. Presumably that person would be paying the same thing that you pay.
Yes.
Right?
Yes.
Okay. So, Mr. Chastain, if you're using the whole thing,
I'm not.
If you're using the whole thing, then don't you have to pay for that?
But I'm not using.
But I didn't ask you that. If you were, let's put it this way, listen to my question.
All right.
If you were using the whole thing, you would agree, we could all agree that you would have to pay for it, right?
Yes, but I'd have to.
If you're using it to the extent that they can't move somebody else in, you would be required to pay that, wouldn't you?
Yes.
Okay.
Case dismissed.
I'm going to tell you, as I'm looking at this, that's what happened.
Oh, wait, he's
Follow me, Mr. Chastain. Here's what the deal is. You're using the whole unit, basically.
They're saying
whether you're admitting that you did, because you're admitting that when they notified you, you basically started putting it back in shape so they could put somebody else in it. You're using that property. And so if you're using it, Mr. Chastain, you have to pay for it.
They wouldn't tell me what I had to remove. I asked for 9 months as soon as it started happening, and they refused to give me something. I talked to corporate. They said it looked lived in. They finally gave me a list in October and said it had to be done by.
But I thought they didn't give you anything.
After I requested it and after corporate came and announced that it was not a friendship suite, they did produce after, I believe, 10 months. So they were.
So before then, Mr. Chastain.
Yes.
Before then, you were just paying this amount of rent, right?
I was paying. And
had no idea why you were paying.
I don't quite understand what you're driving at. Could you give me a little bit more so I can respond?
You were paying twice what you had before, but had no idea why.
No. Everybody that lived with me thought it was very.
I didn't care about everybody else living with you. Your rent doubles.
Yes.
Your conservator knows,
yes.
Right?
Yes.
Your conservator tells you, right?
He tells me when the increase went up.
Okay.
That's all he told me.
And you're saying you paid it and didn't know why?
That is correct. It was because I wasn't meeting the requirements of a friendship suite, and they have never provided the requirements for a friendship suite.
Mr. Chastain. Let's get off of that phrase friendship suite.
Well, it's key to this because
no, it's not.
All right.
Because what's key to it, I don't care what you call it. What's key to it is there's supposed to be somebody else there.
Yes.
And there can't be because you are using the other part of the apartment.
A tiny part, nothing in its bedroom or anything.
But you're using it to the extent that they can't put somebody else in, Mr. Chastain.
Well, that's not true because I've had 4 roommates and nothing has changed.
Judge, this is the letter that Mr. Chastain attached to his own pleadings. It's dated November 30th, 2022. And
which exhibit?
It's Exhibit I to his own pleadings. Maybe it's.
You said it's November 30th?
November 30th, 2022.
Got it.
It says, Dear Steve, as you know, you currently reside in a friendship suite. We have had conversations in the past asking you to clean out the apartment in order for someone else to be able to move in. At this time, we feel that we can no longer offer this as a friendship suite or even be able to show the prospective residents due to the smoke odor, lack of space, and condition of the apartment inside and outside. All of the above are considered lease violations. Then it goes on to indicate how they're going to raise his rent, and they give him until basically the end of December to try to get this resolved. Starting January 1st, his rent's going to go up. So they put him on notice of this, and he attached it to, so obviously he had a copy of it because he attached it to his own pleadings.
See it?
Well, from my point of view, they're making a lot of claims.
Mr.
I see the here.
Okay, and Mr. Chastain, you would agree with me?
No, not at all. The smoke odor, lack of space, and condition of the apartment inside and out is utterly false.
Why'd you?
And they took my apartment.
Mr. Chastain.
Yes.
You told me they never sent you anything.
With regard to why I'm not meeting a friendship suite.
Mr. Chastain, what does that letter say? Doesn't it? Doesn't it?
I'm sorry.
That was a question. What does that say?
I don't really know how to respond. You know.
Well, you're going to need to respond to my question.
All right.
What does that letter say to you?
It says my apartment doesn't meet the requirements of friendship suite, and therefore we're doubling your rent. That's what it says.
And it tells you why.
These, if you look at these,
Mr. Chastain,
smoke over.
Mr. Chastain,
I don't smoke.
It tells you why, doesn't it?
Facts are hard. These be the facts.
They never gave me anything in 9 months requesting what I need to do for a friendship suite. These 3 things, you know, that's their opinion. Fine. Show me the friendship suite requirements. And they didn't have any. They don't have any now. They made up this list particular to me. It's not a policy, and it's not in my lease.
It's a good argument. What does the lease say?
Judge, what I would say is that it's not relevant whether or not any of that stuff is in his lease. What is in his lease is that they have the right to increase his rent with 30 days notice, and they gave him the notice.
Yeah. You realize that, Mr. Chutane?
Well, they increased it. I know that. For 9 months, they didn't tell me why. These are not reasons.
But hold on, Mr. Chutane. Understand something. They could have increased your rent and not given you any reason why.
I'm sorry?
They could have increased your rent and not given you any reason why. On 30 days notice, they could increase your rent. They don't even have to tell you why they're doing it.
Well, that would wind up in court too, then, I guess.
And you'd lose.
I'm sorry?
And you would lose.
That's why we're here.
Yeah. So you can lose.
No, to settle the matter.
So you can lose.
If you say I have no claim, fine. I'll stop here.
I'm going to tell you, I don't see where you have a claim. You're telling me things that aren't true. You're telling me they didn't send you anything saying what they were doing. Do not interrupt me.
Oh, he's done.
You told me that. You told me that you did not know.
That I was in a friendship suite. I did not know. I in the letter I sent to you, I said, I never heard of it before. Nobody I talked to ever heard about this. If it had been in the lease or if they'd sent me the requirements, look at what they asked me to do compared to these 3 vague things they listed in this letter. Look at them. They're specific things. You can't have your toothbrush and toothpaste on the sink. They just made up a bunch of stuff. Ask them to produce the document that says what a friendship suite is.
Mr. Chutane, why do you have a conservator?
I don't. I had some mental issues in the past.
Okay.
10
this
years.
Is over.
12 years.
The conservator.
And at that time, I was not capable of paying my bills. So the conservators worked out. It's not horribly expensive. And he, just like American House takes care of all my needs but a telephone, my conservator took care of all of my needs. So, you know, I don't have any problem having a conservator.
That conservatorship is still pending.
I'm sorry?
The conservatorship is still pending through the court.
No. I've had the conservator court approved 12 years ago when I first moved into American House.
Was that approved through Washtenaw County?
I'm sorry?
Was it through Washtenaw County that the conservator was appointed?
Yes.
Who initiated the petition for appointment of the conservator? Do you know?
I talked to the manager then, and then my conservator took care of the paperwork. I signed the lease back then.
No. I'm talking about the case where you had a conservator appointed.
Yes.
Who initiated that case?
Well, I asked the court to appoint a conservator for me.
So you started it?
I believe so. I don't know who else would have. That was a long time ago, sir.
And I'm just going to tell you this because have you talked to your conservator about this?
Yeah.
Okay, let me ask you this. You don't manage your financial affairs.
No.
And so did you tell your conservator that you were filing a claim that might affect your financial position?
Might affect it? How so? He knows I'm here. He asked if he should be present.
And what did you tell them?
I thought we were going into your chambers, and I told him I didn't think it was necessary.
Oh, I think it's absolutely necessary.
Can I ask why?
Because you don't manage your own financial affairs and you filed a suit for money damages.
I'm not a stupid man.
I never said that.
I suffered for a year because they wouldn't tell me what I needed to
Mr.
do.
Chitain, I'm not calling you stupid. I'm not saying anything about that. I'm just pointing out the fact that you do not manage your own financial affairs.
Correct.
And there is an individual that does manage your financial affairs. What you have filed here has an impact on your financial affairs. And so your conservator should be involved.
Well, he told me just yesterday that if I were to prevail, that the amount should be made out to me with Jim Baker as a conservator.
I know. What happens if they file a claim and you end up owing money?
I asked the court to talk to my conservator. He takes care of my financial affairs.
Said you had a conservator for 12 years?
Yes.
And he knows that you filed a counterclaim.
Yes.
Did your conservator say anything about maybe you having an attorney?
No.
The date is the 25th. No, that's the writ date. They file it then. Need something 10 days after that for a trial.
December trial. 16.
16.
Monday, 16.
No, that's fine. That will work. Because if they have to file the writ, it can be signed and executed. 16.
Yes.
Mr. Chitain, have you thought about getting an attorney?
No.
Okay. So I think that you might want to take a look at it.
If you turn me down,
no,
stop. I don't see any reason to spend more money on this issue. If they think that they didn't lie by saying I didn't meet the requirements of this word I'm not supposed to use, where's the document? That's all I ever asked for, so I can comply with it. And as it got down to the end of the year, they started making demands and they were going to increase my rate even more. So I worked very hard for 2 months to meet their requirements. That isn't a policy. It was specific to my place. And that's not a policy. They say they could have said, we reserve the right that you meet these, and everything would have been fine. It never would have arisen. I have no more furniture in my apartment now than I did when I moved in 12 years ago. I've had 4 roommates. How can they say that I don't have enough space? Okay. Anytime any of them ask.
Mr. Chitain.
Yes.
You told me that the apartment was supposed to have another person.
Yes.
You've also told me that you had things in there that would prevent another person from having basically half of that unit. Why you had it, I'm not even worried about that. It doesn't matter to me. They could not put another person in. They then sent you information of what they saw as lease violations and further informed you that they were going to raise your rent.
Yes.
You may not like it, but I don't see anything that they've done that's wrong.
It seems to me that if they claim that I don't read requirements and they have no requirements on writing, I don't see how that's legal. I have a real problem with that.
Okay, so this is a final settlement conference. You want me to set it for trial, but I'm going to advise you of something before you answer that. They can ask the court to impose sanctions for the filing of a frivolous claim.
If you say so, I don't consider this frivolous. I've got the documentation right here.
Okay.
Yes.
I'm going to advise you that they could ask me to do that and to basically impose sanctions for their attorney's time and for everything else. I would also tell you that I don't see, based upon listening to you, based upon looking at the documentation, that you have a colorable claim in this case. But if what you want me to do, if you want me to set it for trial, I will set it for trial.
I was hoping, and I was under the understanding that I asked for a summary judgment in this matter, so it would end now. Either I win, lose, or you demand that we have arbitration. And that's fine with me. I don't want to spend any more time with this. I think I've been wrong. They've treated me.
And what I would suggest, because they haven't made a money claim against you, what I would suggest, Mr. Chastain, is that you might want to consider dismissing this case against them.
If that's your advice, I'll.
No, yeah, you know what, Mr. Chastain, you don't have to. I'm going to make that suggestion to you. I'm telling you, I don't see anything that gives you a colorable claim.
I'd like you to just drop the case.
You want me to dismiss the case?
Yes.
The counterclaim. Any objection?
I have no objection to the counterclaim being dismissed.
Counterclaim is dismissed. I'm going to do that with prejudice as to the counterclaim. Mr. Chastain, the only thing that I would issue, because the possession issue, they can issue a writ to have you removed. You're going to be out by the 25th, you think?
Absolutely.
Okay, very good.
Judge, do you need me to file anything with the court with regards to the dismissal of the counterclaim? Or the court handle that?
Would you just prepare an order, and maybe you could find a handwritten one that just says defendant is dismissing his counterclaim?
Okay. You would need to sign that then?
If you get it to me right now, I can just sign off on it.
I don't have a form for that.
You pull up a general dismissal form, or is there one out at the clerk's office? We'll get a form, counsel.
Okay.
All right. Thank you.
Thank you.
Mr. Chastain. Mr. Chastain.
Yes.
Come here.
Uh-oh.
Yes, sir.
Has you been treated with respect in this courtroom?
Yes.
And I haven't allowed anybody to say anything to you?
Okay.
You will not walk out and address anybody in this courtroom that may be associated with the plaintiff in that fashion that I just heard.
Fair enough.
I want you to turn around and I want you to apologize.
I apologize.
You may remove the headset and you may leave quietly.
Thank you, Judge.
Thank you. Why are all these other people here? I'm done. I'm going to the Bahamas. Goodbye. No.
After that, I understand.
Who?
Mr. Frank, Mr. Santa Croce, they have two together. I don't know if either.
I got to listen to Fink and Santa Croce
twice.
Oh, man. It's just going from bad to worse. Oh, no, it'd be good because they're students. So I don't have to hear one side of that terrible thing. I'm sorry. I was talking out loud.
For those that are...
Why are you staring at me, Mr. Frank?
Those that are asking about the South Carolina trial, we are not following that one. If you want to follow that, you will have to follow it somewhere else. We're not following
it. Are you...
It's not good for our channel.
Are you going to call my case?
Wow. Wow. How do you say that to me? Did you hear how he said it? Shouldn't you be doing something? Okay. No. I was going to ask, are you ready on either one of you?
We are sort of ready on the Evans matter. I was working on a COD. I let the student attorneys for the defense look at my laptop. I've lost my laptop connection. I can't get back on the Wi-Fi, and I can't get to the documents since they touched my computer. We haven't resolved.
So all of your stuff is broke because they touched it? Good job. They're gonna make fine attorneys.
The second day of class.
Yeah. Well done. So what about the other case?
Looks like a kid sitting there next to him.
These two fine attorneys have been staring at me, wanting me to talk to them, but I was preoccupied by the fact that these young folks who came to Michigan from out of state, both of them broke my computer.
So even if I were to call your case, you're not ready. That's what you're telling me.
We can do the Evans case, Your Honor. I just can't give you the signed COD today because it's 98% completed and I can't get access to the internet.
Hey, we've heard. The court does call the case of Hamilton Crossing versus Tammy Evans.
James Swing for the plaintiff.
Your Honor, Aaron Sanix and Adrian Gonzalez requesting permission to appear on behalf of Ms. Evans, pursuant to Michigan Court Rule 8.120 under the supervision of David Santa Croce.
It was good enough.
It's a brand new
permission to practice
student.
is granted.
Thank you, Your Honor.
Your Honor, we have an agreement in this matter. Ms. Evans' balance as of today is $3,512. She is going to pay $100 a month towards the reserve, towards the arrearage on November 15th, December 15th, January and February 15th. She has $300 held in her attorney's trust account that they will send to my client. She will pay her rent on time from now through February, and she will pay the entire balance due after those payments no later than February 28th. We've got the bones together. We'll just confirm the numbers and we'll submit an order executed by both sides.
So as I'm to understand it, she's going to be paying starting in November. She's for about 4 months, 3 months.
And she's in the process of getting assistance from some other agents.
That's what I was,
including, we're hoping that she'll get Hawk assistance in January.
Got it.
My client has agreed to, she has to keep paying now what she can. And that was the number she came up with, $100 a month plus her rent. And she'll have the entire balance paid by the 28th. If she doesn't, we can submit an affidavit of non-compliance. I put into the order a 5-day objection period so that if our math is wrong or something, the student attorneys will be able to object and we'll get it worked out. But she knows what she needs to do as far as I understand, and she plans to do it.
Okay. So my understanding is once they release the 3, she's going to pay November, December, January. So about $600. That's going to, along with her additional rent, that's going to put her around the $3,000 figure, which would be the cap. She's going to apply for assistance. Hopefully she'll get that assistance, get that paid, and then we'll be done. That's how I see this all working.
I see both client and Professor Santa Croce nodding their heads yes.
Is that correct, counsel?
That's correct.
All right. And ma'am, you understand that? It's okay. It's okay. You can nod. I'll try to ask yes or no question. You understand all of that? Do you have any questions regarding that COD that your attorneys have not answered? Is that a no? Okay. All right. Very good. What I will do then is I will mark the file conditionally dismissed. I will await that order once Mr. Fink gets his computer fixed. Again, good job. And then I'll sign off on it. All right. Thank you.
Thank you. Oh, thank you. I'll send the bill.
Looks like Grizzly would be a good option if you want to watch that that trial, the burn trial. We are court hopping. We've got some big things coming up later in the week, but we're looking for our next court.
I don't think he's ready on the other one because he just said they were staring at him. So now he doesn't have a computer. This is never going to get done. Are you going to talk? Are you going to talk to these fine attorneys here, or you know?
I need to speak to my client for a few moments first.
Okay, that's fine. All right, I've got other things I can do. They'll just have to wait.
May I approach the defense counsel for just a moment?
Sure.
Looking at the Iowa case, the McKinley one, I believe it's a single source trial. Looking to see who's covering that. Looks like Broken Baker, Justice is a Process, Trial TV Live.
Well, the trial of a man.
Let's see if this one's going to work. I think I think LNC is our only camera. I think they're running the show, which might be a little difficult. What's the status of the au pair case in Virginia? I did hear a plea was in the works there.
Case of Jeffrey Patrick versus James Simmons.
I have to ask TYO Toys. He was going to go to that one for us.
Yeah. Good morning.
This
Your name?
Jeffrey Patrick.
Have you seen Mr. Simmons?
I have not.
Okay.
We do want to follow the sheriff and judge Kentucky trial. That is one we'd like to get in on. I might need to see if we have anybody in that area.
They told him he needed
interested and available.
Now what time?
10:30.
10:30. This is set for 9 o'clock. Mr. Simmons is not present. He did contact the court, but he's not here. Would you like a default judgment in this?
Yes, Your Honor.
Raise your right hand. So, hold on. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do, Your Honor.
All right. State your name again for the record.
Jeffrey Patrick.
All right. And what's your claim in this case?
The defendant owes me $3,050 unpaid rent.
$3,050?
Yes.
Unpaid rent?
Right. And I have the ledger this time.
I'm sure you do. I have cost in this case of $91. Judgment to the plaintiff, that is by default for possession. Redemption amount in this case, including cost, is $3,141. Writ issue intended for my signing of the judgment.
Thank you.
So, sir, you'll need to go out, fill out a judgment, provide it to the court for my signature, or do you have one?
3,100.
Pardon?
Do I write it down in here, or I go back out there? Because I have a judgment form right here.
So what are you asking me?
Do I write down the $3,141 in the
Davey,
judgment form?
Welcome. Great to have you here.
Who's that with you?
That's my mom.
Yeah, I can tell.
Yeah.
She's trying to tell you what to do, and you're not even listening. See, that's why you're in this problem. You know what? I did not ask anybody to be here. Do not blame me. Do not blame me. No, because she's trying to blame me. She said, I got to take time out of my day. You told me to be here. I didn't tell you to be here.
But did you ask to see the power of attorney last hearing?
With him? I needed somebody down here that knew what they were doing. That's why you're here.
For some years now.
What?
I said we've been rolling for some years now.
Yep. Well, thank you. All right. You need to fill out the judgment form. I don't care where you do it.
Oh, it don't matter.
But you can't do it at my podium.
For sure.
It's already filled out.
Yeah, but I don't have the 31. I'll just write it down.
I made sure you did everything correctly, except for like that last number. See,
He's going to mess it up. We'll wait.
Oh.
No, go ahead.
No pressure.
No, I know what's going to happen. You're going to mess this up. Do you feel pressure right now?
Yes.
Yeah,
sure.
I figured. Oh, my goodness. Really?
No, that's not right. My bad, John.
I should have just let Mama fill this out.
Trying to learn.
No, it's okay. You're okay. You got 3141. Didn't request somebody new, did he? No, he did not. What about the rest of the man? It's 10 days from today. I'll just do it.
So the 15th.
Just done it myself anyway. All right. I filled it out. You can pick up a copy up front.
Thank you.
All right. Thank you. You do the same. Now she said, I'm going to go about my day now. Take care. Wow. 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 What? Yes, it is. So my watch is dead. What time do you get?
It is 10:30.
Okay.
There's more filings on the 11th and an email from Mr. Recurgy that we need to talk about before you go.
Finney versus Sidoni.
Morning,
Good morning. State your name.
Where were you? Brooke Sidoni.
Peter Sidoni.
All right. Have you guys had any conversations between the last time we were here and today?
We haven't, but I am open to that.
Okay. Open to that in what way?
Conversation about
Go ahead. You guys can have a seat. About trying to resolve this.
yes, correct.
Ma'am, you're open to that also?
Yes. On top of that, I was looking through my DTE and I found some receipts that I paid $500 back in March 2020. And I paid it because it was on my name and it was on my mail. And I have the receipt here from the bank statement. I just saw it last night. And this is the one that I didn't turn in.
Okay. I'm not gonna deal with that right now because I don't know that's gonna make a big difference. So there was 29. I don't have my actual notes. Mine are sitting on my thing. What was the amount of the insurance proceeds?
29,579.
That's right. 29,579.
Yes.
All right. And of that amount, no, they're on my, I know where it is on my thing. Now, in terms of trying to resolve this, folks, I mean, there's a number of ways of trying to resolve it. One way of resolving it is to go through item by item, figure out what it is. Now, do you guys really want to do that?
I have all the items.
Where'd that come from?
My lawyer did a spreadsheet, Friedman. Everything here is mine and hers.
Okay.
Your Honor, we supplied that to the lawyers, and we also have the list of whose. So we did do that, correct?
Okay. So when you go down that list, that doesn't have valuation though, does it? Does it? Let me see it.
Insurance, correct? And we also
You
did.
gave that to the insurance?
We're going to bail just a little bit on this, and we're going to find another court that we haven't watched a lot of, but it's just gone live a little bit ago, and that is Judge Fleischer. Good morning, Judge Fleischer. How are you doing? Judge Fleischer can really crack down on somebody when he wants to. We're going to watch Koberger in 2 days. Go to hearing in 2 days.
From me.
We are not watching the South Carolina via Craig Lewis trial. We're not following that one. First of all, it has brutal domestic violence, rape, torture, and immolation while alive. No, it's not going to be good to follow. I can't do that. But a lot of good people are following it. Grizzly's going to have it. My only complaints about Judge Fleischer is his courtroom is noisy.
That's right. Do you have a specific thing you want to know, or just prosecution? Okay. For you, got it. Okay. I'll have my gang.
Grizzly's good at that. She'll do well with that. Let's see if he's ready to call his next case here.
Hey, Judge, quick question.
Yeah, what? Still recovering.
Midway between the programs. So if the program is like 3 months, month and a half way, we bring them into, you know what I mean?
Great.
So we'll bring them in January, you know?
Well, sometimes it can be your fault, but
it wasn't.
It wasn't.
If it takes much longer, I'm going to be reading the Boone document.
That's fair. I'm not many.
You help us out today?
Yeah, I do. Corinne's Tina.
Oh, I just. Yes.
Okay. So I saw that he was talking about like injection.
Yeah.
Yeah.
So he has a pretty large. Yeah. And he's done injections, he's done MRIs.
Yeah. Yes. Most of the time, they send it to like definition therapy.
Okay. Boone document it is, but I can't put it on the screen. Is that all right?
Whether or not this is one we're like, it's legit.
All right, we'll come back to Judge Fleischer in a little bit. We have a motion that was just filed, looks like yesterday in the Sarah Boone trial, which, as you know, Sarah Boone has been convicted, and she is awaiting her sentence, which will come here soon. They're doing a pre-sentence investigation. But she's filed a motion State of Florida v. Plaintiff Sarah Boone comes down to the defendant Sarah Boone by and through counsel, so through her lawyer, and pursuant to Rule 3.6, Florida Rules of Criminal Procedure, files this motion for a new trial, stating in support thereof the following. So here are her claims. 1, the defendant, or these are the facts. The defendant was found guilty as charged of second-degree murder on October 25th. The instant motion was timely filed pursuant to the rule. That means that this motion is within the window that they're allowed to file it. The defendant asserts that she's entitled to a new trial under Rule 3.6 on the following grounds. The court erred, I think erred is the actual correct pronunciation, but the court made an error, that the defendant was not entitled to court-appointed counsel. Now, this is going back a ways. So the court made a mistake saying she was not entitled to court-appointed counsel. She had to find her own counsel. So she's saying that's a problem. 2, the court erred in denying counsel's multiple motions for continuance. So when she did find counsel, they didn't give them extension of time. 3, the court erred in failing to grant a new trial when the alleged victim's family caused an emotional outburst in open court in the presence of the jury prior to deliberations. You remember the time that some people broke down crying? They're saying that's motion for a new trial. 4th, the trial court failed to disallow the opinion testimony of the state's rebuttal expert witness, Dr. Tonya Werner, after the state failed to disclose before trial that the witness had formed a new opinion. There was a big battle about that one in motions. And 5th, the state committed prosecutorial misconduct by essentially making a second closing argument instead of a rebuttal argument. I don't remember them objecting to that in the moment. Did they do that? I'm not sure if they did. So here are their arguments. For argument number 1, the trial court erred in holding the defendant was not entitled to court-appointed counsel. In the above-styled case, the defendant had approximately 7 court-appointed attorneys prior to the undersigned counsel taking her case. Approximately 7. That would be 8. Undersigned counsel took on the case because he was concerned that Ms. Boone would not have an attorney to represent her at trial. The above case was very complex, even for a seasoned trial attorney who was the public defender of the First Judicial Circuit for years, as well as having a thriving private practice. It was apparent to undersigned trial counsel that Ms. Boone would be grossly ill-prepared and unequipped to handle a trial in this matter, or in fact to handle any other phase of the trial without counsel. Both the Sixth Amendment as well as Rule 3.111, Florida Rules of Criminal Procedure guarantee an indigent defendant the right to appointed counsel. There appear to be 2 exceptions to this precedence. 1, if the defendant physically harms or threatens to harm, rape, battery, etc., his or her counsel. You can't do that to your lawyer. Just in case you thought that was one of the benefits or perks of having a lawyer, it's not. 2, if the trial court certifies that the defendant will not be incarcerated if found guilty, i.e. a judge trial, should the court determine that the defendant is not entitled to court-appointed counsel due to misbehavior on the part of the defendant, the court must follow a process which protects the individual's right to due process, as well as the defendant's right to the assistance of counsel. In the instant case, undersigned trial counsel would assert that Ms. Boone's behavior did not rise to the level of misconduct to warrant a waiver of the right to court-appointed counsel, and if the court determines that she waived her right to court-appointed counsel, then the court failed to warn her or inform her that her continued misbehavior would result in a waiver of the right to court-appointed counsel. Under the controlling precedents, failure of the court to appoint trial counsel can result in a motion for a new trial being granted. This gets a little... There's a lot of words in here, but when Sarah Boone was, as the judge said, causing delays and causing problems with her attorneys, they ruled that because of the delays and the problems she has caused, she is no longer eligible for a free lawyer provided for you because she's indigent. So they said, nope, you're now on your own because of your actions. She is saying that the way the court went about that, they violated her rights, and so she gets a new trial because of this. Let's see. Under controlling precedents, Florida Rules and Criminal Procedure, and the Sixth Amendment, the defendant through counsel moves the court for a new trial. Argument number 2. This is that the court made a mistake when failing to grant the defendant's motions for continuance made by undersigned trial counsel. Once she did have these new lawyers that represented her at court, the first thing they did said, Judge, we need more time. And the judge said, nope, we're moving forward. The date is set. You've got to get ready. You've got a month, basically. Get ready for your murder trial. Let's see, they came in when the case was 4 years old. He filed his notice of appearance on August 30th. This gave counsel 45 days to prepare for a second-degree murder trial. He immediately and aggressively began to prepare for trial. The counsel did his best to prepare for trial by traveling to Orlando from Milton on multiple occasions, meeting with Sarah Boone and attending multiple hearings. Despite his best attempts to prepare for trial, it was impossible to adequately prepare for unforeseen issues arising during trial. A prime example of this would be reviewing hundreds of pages of text from Miss Boone's seized cell phone, viewing all records of prior contact of Miss Boone and the alleged victim with law enforcement, including inadmissible hearsay by the alleged victim to law enforcement regarding Miss Boone being the aggressor at times. Counsel, for all purposes, closed his law practice down to prepare for trial, but due to the short time frame, even with the assistance of other attorneys, he was simply logistically unable to be as prepared for trial as he would like to have been, and as Miss Boone was entitled to. Under the controlling cases, the court's failure to grant Undersigned's counsel motions for continuance should result in a new trial. Argument number 3. These are the reasons that Miss Sarah Boone wants a new trial. Number 3, the court erred when it denied a motion for a new trial due to an emotional outburst in the presence of the jury. Now this, I do remember the objection being raised by the defense, and it was amazing. The drama that was injected in the motion was unbelievable. They're like, Your Honor, I've never, in all my years of court, seen something like what we just witnessed, where somebody, a victim's family member in court, burst into tears in front of the jury. Really? You've never? It seemed fabricated, but they're using that. They're including that in this. Obviously, that was done intentionally, so they would have this grounds to file a motion. So they've preserved this for this appeal. Prior to jury deliberations, the alleged victim's family members began to audibly and visibly get upset and departed the courtroom. The counsel moved for a mistrial, requesting a new trial. The court did not give any curative instructions or address whether the outburst could adversely affect the jury deliberations. Florida appellate courts have held that the failure of the court to grant a curative instruction or a mistrial can result in the necessity of granting a new trial. The court is unable to determine if this outburst affected the jury's decision because no inquiry was made. Under controlling precedents, the defendant is entitled to a new trial. Argument number 4. The court erred in allowing the opinion of the state's expert not previously disclosed. Now, remember this one? We had a witness, the expert got up. She was the one that said, yes, I believe that there is battered spouse syndrome elements there. She had a little bit different opinion on some things than what she had shared previously. And hang on, I'm going to back this up just a tiny bit. The trial court failed to disallow the opinion testimony of the state's rebuttal expert witness, Dr. Tanya Warner, after the state failed to disclose before trial that the witness had formed a new opinion relating to whether the defendant perceived an imminent threat at the time of the offense. This issue was discussed extensively by the expert witness deposition. The state committed prosecutorial misconduct, which is not a small accusation, by failing to disclose this new opinion as agreed in the deposition mentioned above. In addition, the state's expert opinion on whether the defendant perceived an imminent threat necessary for justifiable use of force and battered spouse syndrome testified to before the jury was improper. The state's expert admitted she had not listened to the defendant's testimony before the jury before forming her opinion on this ultimate issue of fact. In addition, Dr. Warner failed to listen to the testimony of Dr. Brannon and Dr. Julie Harper before expressing her opinion. This is interesting. They slide this in under the heading of this new opinion was not disclosed and should not have been allowed. And then they also attack, and we don't like how she reached this opinion either. But how she reached the opinion, frankly, doesn't matter in this, and they just wanted to sort of get in more bits and pieces and peripheral data. In addition, the state's expert opinion was improper. Furthermore, the state's expert testimony on this issue of whether the defendant perceived an imminent threat at the time of the event, like the fingers coming out of the suitcase, violates the province of the jury. Witnesses are prevented from expressing their conclusions when opinion only tells the jury how to decide the case and does not help the jury determine what occurred. When a witness is asked to express an opinion that applies a legal standard to a set of facts, the opinion testimony is generally inadmissible. The law does not permit a witness to testify to legal conclusions or express an opinion upon questions of substantive law, and that's case law there. The testimony may interfere with the function of the trial judge to determine the applicable law and to instruct the jury thereon. There's more case law. Argument number 5, that's last and final reason why Sarah Boone should get a new trial. The state committed prosecutorial misconduct by essentially making a second closing argument instead of a rebuttal argument. Counsel for the state made a second closing argument posed as a rebuttal. Wherefore, premises considered, the defendant seeks the relief sought herein, as well as other relief to which he may be entitled. Defendant requests a hearing in this matter. So this will go to court. There will be a hearing, I think, and it will be short and it will be denied, most likely. But interesting reasons for why Sarah Boone is supposed to get a new trial. I don't remember if the defense objected to the closing arguments by the state or not. But let's see. I'm just looking. It looks like there is a hearing scheduled. It is for December 2nd. That's the sentencing. We might have this other hearing probably in the next week or two. At least find a schedule for it in the next week or two. But apparently Sarah Boone thinks a redo can bring about a different outcome. I'm not so convinced. All right, let's jump back just a little bit because it looks like Judge Fleischer had a bit of a spicy one come in here. Let's see what happens here.
Not asking much. All right, take a seat, Mr. Ramos. I'm not ready to rule yet.
All right, Judge, our next Spanish arraignment is page 5. Cruz, come on up.
Edna's here. Hi. Good morning. You are Luis Guillermo Acosta Cruz.
All right.
Sir, you're charged with failure to identify oneself by giving false or fictitious information. You're facing up to 6 months in jail and or a $2,000 fine.
Order in the court.
We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, sir. The officer observed a vehicle speeding 50 miles per hour in a 35-mile-per-hour zone and failing to maintain a single lane. A traffic stop was initiated, and the driver was placed in custody due to the traffic violations, and the officer made contact with the defendant, the passenger of the vehicle. The officer observed signs of intoxication from the defendant, including bloodshot eyes, slurred speech, and poor balance, and the officer asked the passenger to step out of the vehicle because it was going to be towed. The officer asked the defendant to identify himself, and the defendant stated his name was Martin Sevilla Vargas, with a date of birth of November 16, 1982. The officer detained the defendant for public intoxication and identified the defendant with APIS. I agree, Judge. Yes, whatever you're about to say, I agree. Yes.
I want to beat my head against the wall. I really just dunk. Mr. Cruz, I'm going to find that there's probable cause to go forward with the case. I want to inform you now that it's very possible that they charge you with driving while intoxicated out of this event. And I don't know why they didn't charge you with that as it is.
Judge, to be clear, this defendant wasn't in the car. He was a passenger.
He was a passenger?
No, he was the passenger. Yes. And yes.
He was a driver. Say that again?
I'm dismissing the case.
Which one?
The case you just found no probable.
You're on him?
Did you find probable cause? Just for clarity.
I was going to find probable cause.
Okay.
I'm going with the state. I thought that he was oh, no, Your Honor. I thought he was DWI.
So let me just break down to you.
Did you not say he was the driver of the car?
He was the passenger.
I thought you said.
No, he's a passenger. They detain him.
Maybe I need to go have like my money. No.
He gives a false name. But they pull him out of the car, then they detain him for public impulse after they're the ones that pull him out of the car. And then they aphis him off of that. And then they find him.
Think there's enough probable cause to go forward on a failure to ID?
I think that technically he meets the statute, but I think that it was, I don't think that they had a right to arrest him for class C public impulse after they're the ones that put the games in public by pulling him out of the car.
Okay, I'm gonna find no problem.
Okay, so
today's your lucky day, Mr. Cruz. But I wanna impart something to you. If you're not in this country with permission, and you get in trouble, and you go to jail, and immigration finds you, they're going to put an immigration detainment. So if I were you, I would be on your best behavior, because the next time you might not get so lucky, and you could be very well spending the next 10 months to a year in jail. Do you understand? When you hang with dogs, you get fleas. Especially if you have a bunch of little kids that depend on you, a wife. Don't act a fool, because the next time I might keep you. You understand? All right, buddy, you're free to go. Thank you.
Julie, congratulations on 18 months. Yeah, it was his lucky day. It was a passenger at a DUI stop. There was failure to ID.
Red count?
Yes, sir.
And found there was no probable cause.
Good job, Michael.
Did you have a Tina Perez, Perez?
While we're doing that, I just wanted to show that one. I like seeing when a judge dismisses a case, saying there's no probable cause. Let's see, search. There we go. Which one we need? Josh, I see the link. I'm just trying to pull it up right now. And it's 3. Okay. Two hours ago. Okay, that would be this one. Starting at 43 minutes. Josh has sent us a good one, apparently. 46 minutes. Okay. All right, so we're going to jump up to Thurston County, Washington. This happened yesterday.
This Jesse Paul Davies, 24-369. And
I posted both the videos on my channel, on this channel.
Jasila?
Just
okay.
It's not live.
Make sure I get everybody's name right. Tahiry, Tahiri. Okay, and you are?
Jack Brown.
Jack Brown, okay, that's both petitioners, and you're Jesse Davies.
I am Jesse Davies.
Okay, and are you here with him as a support person?
No, he's asking me. My name is Diane Brown, and in all the evidence, especially the newest printed evidence that was submitted to this court, 1028, filed with this court 1028. I didn't have an opportunity to get that until I think late last week, and the videos, which I couldn't view until I got a computer technical person to assist me. they made it real clear that this isn't just between the petitioners and the respondent, but my name and property and house address are listed throughout, even in the police reports prior to that.
Okay, let me kind of slow you down right there. Who are you in relation to the case? I see you're
I'm
not
the property owner.
The property owner
The property owner of 3921 Balsam Avenue Northeast. And have knowledge of much of their evidence.
So are you a witness then?
Yes, I would say I'm
one of Mr. Davies's witnesses. Is that it?
Or I would have knowledge on many of their the police reports. I'd have knowledge of.
Is she just a nosy neighbor?
The printed.
Thank you, Tammy. Thank you so much.
Printed part.
Well, let me get started here on the case, and we'll see how this develops. All right.
Thank you.
So, Mr. Brown, Mr. Here, you brought this petition for an anti-harassment order against Mr. Davies, and Mr. Davies is here in response. Mr. Davies, are you ready to proceed?
Yes, Your Honor. I feel like I am. I feel like I'm fully prepared to defend my.
That's all I need to know.
Understood.
All right. So, and I take it that the petitioners are ready to proceed as well.
Yes, sir.
All right. So this is what we'll do. I'm going to swear you each party in, and then I'll decide the case. Now, keep in mind that generally speaking, cases like this are heard based on evidence that's filed in the form of declarations, which has been done here. It may or may not be necessary to take any additional evidence in the form of testimony. That just kind of depends. We'll see. But I'll give each side an opportunity to present their case. And so that's the petitioners first. So they'll present their case. I'll listen to that. I'm going to ask that they not be interrupted in that. And then after they've had the opportunity to present their case, then it'll be the respondent's turn. That's you, Mr. Davies. Same thing. You'll present your defense to this petition. And same thing, no interruptions with that. Except that I may need to ask questions. If I need to ask questions, those would be the interruptions. Okay. And I will only do that if I really need to be sure that I understand what you're telling me, or if I need to help sort of direct you onto facts and circumstances that'll help me resolve the case. Okay. And then after I've heard from both sides, I'll make a decision as to whether or not an order is going to be issued, and I'll explain to you kind of the reasons why. If you saw the last hearing, you saw a little bit of that. All right. So with that in mind, please, the parties, please raise your right hands. Do each of you swear that the testimony that you give in this case will be the truth, the whole truth, and nothing but the truth?
I do.
Okay. I do. All right. So Ms. Tahiri and Mr. Brown, you get to go first.
Good morning, Your Honor. Thank you for hearing us today. I'd like to start off by saying that Diane Brown is correct that she is not the respondent, but she is incorrect that this case is about her or any issue that may have arisen with her and I and my wife being neighbors. This case is strictly about Jesse Davies and his knowing and willful course of conduct that has alarmed, annoyed, and harassed both my wife and I, serving no legitimate or lawful purpose. Mr. Davies has violated the Washington Administrative Code 173-60 multiple times for Class A EDNA, which is what both of our properties fall under. They're both residential properties. I've submitted noise measurement reports and decibels. It's a free application called NIOSH Slim. NIOSH comes from the National Institute of Occupational Health and Safety, was something I learned about during HAZWOPER training and refresher courses over the years. This noise has exceeded all OSHA requirements in both quantity and time of duration. OSHA states that at these noise levels, one should be wearing hearing protection, and their exposure to this noise should be limited to less than 8 hours a day. Sometimes the noise that is starting this has gone on for up to 10 hours a day. Prior to notification of both parties' awareness of this, Mr. Davies has peered through the windows of our home, starting at my office window, which does share the property line, my wife's office, which is at the back of the house, and he needed to actually reach the rear corner of both of our properties to do so and lean underneath the foliage to get a good look through us.
Oh, he said the F word.
He has
Foliage.
leaned down trying to see underneath of the blinds at the front of our house to peer in when the blinds are cracked open for our dog to look out. And it's honestly gotten to the point that we are quite alarmed. We were unaware of a lot of this and his potential for harm until Mr. Davies had told me a story of him hurting a girlfriend who left his house that morning to go live down in the jungle encampment. He had explained to me that he had gone down there looking for her and that some men had been angered about him searching for this woman. And he was worried that these men would come to his mother's property trying to find him. And he was worried for her safety, asking me to look out for her. I agreed. We had always had a cordial relationship with Miss Brown, and there was no issue between us at this point. Mr. Davies has crossed our property line numerous times without invitation to come talk to my wife or I when we are in front of our garage. It was our own naivety that did not tell him to leave because we were, again, cordial with our neighbor and her son.
I'm getting the goat ready.
Starting on September 11th, around 12:30 in the morning, Mr. Davies was sanding a RV trailer that he's been attempting to remodel in the driveway of Miss Brown's property. This was prior to all of this noise going on, and it was kind of my final breaking point, that he was outside of the standard hours of noise for a neighborhood, being after 8 p.m. At 9:37 in the morning, I texted his mom saying, hey, he was out there doing this in the middle of the night. That is substantiated in the text documentation between myself and Diane Brown on pages 9 and 10. Mr. Davies was relatively quiet that morning, and I have reason to believe that it was after that text message went out, his mother had contacted him and told him to keep it down, as she was not home at the time. The first time that Mr. Davies began pressure washing was as soon as I had somebody come over to the house to look at my boat, which is on the side of the house which our properties share. Person interested in the boat came over at 6:51 p.m. and left just before 8. The pressure washer turned on the moment we were out there and turned off the moment this man left. This was the first
awesome.
day that he was not pressure washing for the better part of the entirety of the day. The pressure washer was placed within 10 feet of myself and the person interested in the boat, and within 5 feet of my property line. On September 12th, Mr. Davies pressure washed nearly all day. At 5:06 p.m., I took a decibel recording showing a 79.8 decibel reading, peaking at nearly 95 decibels. Again, this is exceeding OSHA limits for even with hearing protection for over 8 hours. At approximately 5:10, I walked over to ask Mr. Davies to please move the pressure washer onto the other side of the RV trailer he was working on in hopes that it would at least stop some of the sound from ricocheting between both of our homes, because that was the majority of the issue with where the pressure washer was placed. I understood that he was working on a project and I wasn't trying to interrupt him doing what he was doing. However, I explained to him that it being right outside my office window was causing me severe anxiety, headaches, and I honestly couldn't focus on my work. I do work from home. At 5:25, I ended up making a noise complaint. I had asked Mr. Davies before I did this one more time to please move it onto the other side of the pressure washer, or I would be making a noise complaint. I did this within view of him, and at 5:32 p.m., Olympia PD officer R. Donald had arrived. Mr. Davies had stopped, cleaned up shop, and was nowhere in sight. I believe this is because I did say I was making a noise complaint and he did not want to be doing this action when PD had arrived. On September 18th, Mr. Davies witnessed my wife and I out on our property. I truthfully don't remember what we were doing, whether we were gardening or walking the dog, but he immediately began pressure washing as we had walked out onto the property. This was the day I made my second noise complaint. This was 6 days after I personally notified him that these actions were annoying and were harming us, and 7 days after I had notified the property owner of these actions as well. I forgot to mention that in that notification to the property owner, I did state would be happy to share the Washington Administrative Code that he was in violation of. I did say that if this continued, I would be making a noise complaint and that her address would be listed as the property, as this is where these occurrences are happening, but that Jesse Davies would be the one named in whatever action to be taken. On September 19th at 11:26 a.m., I made yet another noise complaint. I have a 1:43 p.m. reading showing 65.1 decibels, peaking at 85 decibels, again, over the the OSHA limits of what is acceptable for working conditions.
I'm gonna go download this app.
At 3:24 p.m., Olympia PD Officer Jay Watkins arrived to Ms. Brown's property to discuss our complaints with her. Speaking with him on the phone, he had asked if we would like him to go speak with her, and we did. The property owner states in this time that Jesse Davies does not live there, and she also does not believe that any of this is happening and that it is wrong, or that it was not wrong, I'm sorry. But again, she was made aware of this 8 days prior, and he was made aware of this also 7 days prior. On September 24th, I took yet another reading, 75.1 decibels, peaking at 99.7 decibels, and made a noise complaint in the following minute. I believe it ended up turning off.
I made a noise complaint the following minute.
Wasn't happening anymore, and that nobody needed to arrive.
His finger was on the button. He's like, there it is, boom, complaint.
On October 10th, Mr. Davies heard my wife and I outside as we were preparing for a dog walk. As he was riding his bicycle out of his mother's driveway, he diverted his bike from the center line of the roadway onto our side of the street, came within approximately 5 feet of us, slowly passing us while turning both of his shoulders to our direction, menacingly staring and moving closer aggressively to us.
Mr. Brown, you don't have to repeat everything that you've already submitted in declaration form. That's kind of the reason it's submitted in declaration form is I've seen this and read this, and so it's not, you don't have to say it again. But if there are specific things, if you want to argue for your case for an anti-harassment order, you can point to specific, instances that are supported by the declarations that you filed. That's fine.
I guess I'm just trying to really hit home the point that both parties to my right have been notified for this actions for over a month on end. And that originally we did try to solve this between neighbors.
Okay. 100 decibels.
Mr. Davies,
my
let me hear from you.
100 decibels.
And just to remind you too, I have the material that was submitted on your behalf too.
That's the Christmas goat.
Your Honor, is that what was filed on
the other goat was
November 1st?
Yes.
The handwritten document?
The other goat's 96. Christmas goat is louder by 4 decibels.
Yeah, go ahead, Mr. Davies.
Your Honor, I feel a great relief that the court is now handling this matter, and I am thankful for that. I realize that this is probably my one and only chance to tell my side of the story. I will do my best not to waste the court's time. My mother, Diane Brown, owner of the 3921 Balsam Avenue, Northeast Olympia, Washington, 98506 property, is here in the courtroom today and wishes to be heard by the court. What she has to say definitely pertains to this case only. She is fully prepared to answer any questions that the judge might have about this case, as this matter greatly affects her. Your Honor, the petitioners of this restraining order that has been placed against me bought the house next door to my mother's house not too long ago. I visit my widowed elderly mother quite often. My mother needs my help with a variety of things, so I come and go, and I am there quite often, helping my mother with a variety of things that she is unable to do. My mother and I have been experiencing a constant bombardment of a very wide variety of complaints from the petitioners of this restraining order. It has been very stressful and mentally exhausting for both my mother and I. I have often wondered, why are they doing this to us? No laws have been broken. A lot of complaints are about me making noise at times when I am not even there. Or they claim that I am running power equipment after the noise ordinance shut off time. And now, for a long time, they just call the police on me anytime there's any noise they don't care for in the neighborhood. Quite often, for long periods of time, the lady petitioner rarely misses a day of screaming insults at me at the top of her lungs from her property. So I just hear these unfounded accusations and insults. Your Honor, I have never responded to any of these screams at the top of her lung accusations from the lady petitioner. Not even once, Your Honor. I have no wish to participate in any bickering with my mother's neighbors. Harassment is a form of violence, and I know that. I did not even know her name before this restraining order was placed on me. Your Honor, I am sure that you are aware of the fact that I do have a domestic violence on my record. And while I am not proud of that, I went to all of my domestic violence classes that I was ordered to by the court. I paid attention in class, and I had a really good teacher. My teacher even allowed me to go to his classes after I graduated, and I took advantage of that. So, Your Honor, I hope you can see that I have no wish to bicker with, harass, or any other form of violence towards petitioners. I understand that petitioners are saying that they fear I will harm them. I can assure you, Your Honor, violence is not and will not be an option for me. I have not and will not ever allow myself to even entertain the idea of that. Although I have left my mother's property and distanced myself as a result of her screaming insults at me, the petitioner of this restraining order constantly tell my mother that the petitioners, excuse me, Your Honor, of this restraining order constantly tell my mother that none of this is against her, while my mother is the one that has been negatively affected the most. My mother is not one to complain, but she is worried she will have to sell her house to get away from the petitioners and the stress of having to deal with their constant bombardment of unfounded complaints. Your Honor, I know that that it's okay to experience anger, and it's just what we do with it that matters. I know why the laws are the way they are, and I know that they save lives. I'm not upset with this court or the petitioners for placing this temporary restraining order on me. About the video evidence with me and the leaf blower, I was scared. I turned around only to see if she was chasing me, so I would know if I had to run or not. To get away, I was shaking because I was scared. I revved the blower on accident. I am grateful to offer through the court my apology to all involved and through the court to seek a peaceful resolution only.
I revved the blower on accident?
Your Honor, that's what I have. That's my statement that I prepared. I really feel like any of these accusations against me, that I feel like I did prepare a defense for them but I don't feel I need one. They're just accusations. I'm not guilty of them. And so I'm prepared to respond to any questions that you might have, Your Honor. And please allow my mother to talk, as this case greatly affects her. And so I think that's all I have, but I would like to answer any questions that you might have.
I think I just really only have a couple. Just so that I'm clear, you don't live there with your mother?
It's not my residence, no.
Okay, you live someplace else.
Excuse me?
You live someplace else, but you come over a lot to help your mother.
Yes, that's correct.
Yeah. All right. I think that's just what I want to make sure I understood clearly.
Well, if I may, I'm pretty scared that I won't be able to help her anymore, and I'm scared that this is affecting her health. And so I'm not. That's all I have. That's all I have. Yes.
But you want me to hear from your mother?
What's that, sir?
You want me to hear from your mother too?
Oh yes, if you wouldn't mind, I would appreciate the court to patience and time and thoughtfulness.
And
yes, please.
Ms.
Thank you.
Brown, why don't you raise your right hand, please? And do you swear the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay. So, Mr. Davies, what would you like to add? Would you like to ask your mother questions?
I'm not good at this. I feel that no matter what happens with this outcome, I just feel she deserves a chance to speak. So, because it greatly affects her. I don't know that this will help my case.
Let
her talk.
If you don't mind, then
it does pertain. It definitely pertains to this case.
Can I ask you a couple of questions then?
I hope you ask me a lot of questions.
Well, I'm just going to have a couple. I want to make sure that this is sort of fairly heard. And
Right.
so, the petitioners have brought a number of allegations about specific things that your son has done related to noise, related to trespassing, related to peeping. Now, do you have any personal knowledge from your own experience, in other words, seeing or hearing yourself, not hearing about it from your son, but just observations yourself that you can tell me about these allegations that Ms. Tahiri and Mr. Brown have brought?
Okay, I did get this printed evidence they submitted just recently, and I couldn't respond to everything that I saw that was like partial truth, taken out of context, untruth, things like that. I couldn't respond to all of that, all of the police reports and other things that were submitted in writing. And I'm telling you the reason why. I'm going to try not to waste your time too. In a one cohesive written, document and submit it to you in time, because I'm 70 years old and like many seniors, declining. I'm slower in thinking, concentrating, acting on deadlines, organizing thoughts and written documents, reading and spelling. I can't do many things that I used to do. I can't climb on my roof. My balance is bad. I can't do heavy lifting, sun exposure. I have torn meniscus in both knees, curvature of the spine, and I can't do many things that I could do 40 years ago when I was about the petitioner's age. I can't do them. I don't have technical equipment and I don't know how to use it. I even purchased a laptop on Monday and had it hooked up by professionals on Tuesday, but I didn't even know how to use it. And so I would be trying to write responses in time and then I'd rip them up, and then I would be in bed with severe headaches and diarrhea. And I don't wear Depends, but I wear them now.
A lot of information for court.
So my husband had a stroke in 2009, and his care was expensive, even though I did very much of it. Had him with me for years. He was in an adult family home for 5 years. That depleted our resources. So it's not like I can hire people to do things for me, to like do repair projects or maintenance and things like that. And I operate with hand tools because I don't have to keep them running. So unlike other widows in my loop, I can't hire too much done. So Jesse comes over and does big projects. I mean, they make it out to sound in their documentation that he's on the roof peering in their windows. And I mean, he worked on the back porch. I have pictures of it, of what it looks like. And it requires a lot of high up work on ladders and things like that. And I don't think I could even peer in their windows. The thing is, we have I'm trying to make this short, but I know I'm skipping a lot of stuff. We have a very narrow boundaries between their west side and my east side, very narrow. Most houses in our development, the houses are placed more in the middle. But with ours, it's a very narrow between our boundaries. And they happened to buy a house that had very narrow boundaries. And some of the issues with foliage and stuff or peering in, I mean, they removed
foliage or
several trees and a lilac bush, a big one, and a lot of stickery foliage from their back side that boards the green belt. And so that made the whole, I think it's south side of their property, very visible to people that, like, sometimes a lost person or a homeless person comes and cuts through their yard or cuts through my yard. Well, if it happens to their yard, they really come unglued and are really paranoid. I just tell the person, here's, if you want to get to Bolsom, go that way. You know, okay, finish going through my yard because they're
Go
in the
through our
middle of
neighbor's
it.
yard.
Or go back to the Greenbelt and go out to Slater Kenny. I was really happy that you're giving me an opportunity to talk, because I even wrote something up about that will educate you more. At least you can take about our neighborhood and the traffic.
Yeah.
So
Thank you, Tammy.
the street we're on, Bolsom Avenue Northeast, goes from Slater Kenny back to the Chehalis Trail. You go up that block and you have access to the Chehalis Trail, back and forth. And so we've got local schools, people, we've got regular bikers that some of them look like, you know, professional, you know, bike riders, and some of them look more like they're homeless and stuff, and people going to work via bikes and cars and walking and
all through our yard.
So that's kind of like the traffic around and the noise around. Now that I'm talking about noise, I question why they didn't go to code enforcement, because at first I didn't know that some of this stuff was police reports, and I didn't know that I could ask for copies of them. Once I asked for copies, I mean, if I have a file that contains the police reports, and if you allow me, I could go right through and say there's a lot of things that I thought, if the judge did have time to look it all over good before, would be amazed at the wording. I mean, one of the police reports, it doesn't even have the petitioner's name on it, one of the police reports, on who made the complaint. And there's one that you can't even tell if it's against Davey or the homeowner or both, because the police report might say they and them. And so who is they and them? They're just poorly written and misleading. And if I had them in front of me, you allowed me the time, of course I could tell you that. Same with, if I was allowed the time, I could go through all things in here that are
She's grammar checking
untrue.
their motion.
I mean, my side of the story is, and you know, if you care to read what I wrote about the noise in the whole neighborhood, and other people doing remodels and adding porches and cutting bricks, very noisy, dirty things that can get a neighbor's car dirty, or just a lot of this noise complaint. And I just question why they didn't go to noise enforcement. Once I realized that the complaints were all police department reports, I went downtown and because it was just next to the police department where I got a copies, and talked to someone that I used to know from St. Martin's College, because he was a business owner. And I explained about all the noise complaints, and he said, well, you need to go to noise enforcement. So I went up to noise enforcement on the 24th of September, and I talked to Jeff Finch and Dylan. I've got their cards in my wallet, and I submitted them, even though my table of contents and things were late. I did submit them, and I knew it was really late, but I'd been in bed most of the week and didn't have the equipment to reply with. So I did the best I could as soon as I could. Like I say, I don't have the ability to do like a college thesis, all, like in the right format and everything.
APA format, please.
Anyways, I went to noise enforcement on the September 24th. And when I explained how one of the policemen treated me, they said our officers would never do that, because I wasn't allowed to speak. I asked for a copy of the ordinance and they wouldn't give it to me. And I really, in my mind, questioned, and I'm not a paranoid person, but I questioned if it was really even a police officer or someone that was.
Ms. Brown, Ms. Brown, I'm going to kind of pause you right there, because I know this is important to you,
because I need
but
to go take some Advil.
The things that you're telling me are not particularly relevant to the issues before me in terms of resolving the petition. So
I have one more
I'm gonna
really,
kind of, I know you want to say things, but I'm just sort of put that aside in your mind for a minute, because I want you to be, if you can be, this isn't a requirement, but I want you to, if you know, tell me what happened with regard to these incidents that have been raised by the petitioners, right?
okay, what happened about these incidents?
Yeah, if you know, if you were there, if you saw it or heard it yourself. There's been allegations raised about what Mr. Davies did. And if you know anything about that, can you respond to that? If you don't know anything about it, that's fine too.
I do know about some of them. I do know about some of them. I saw the video, I saw a video that was put on my email, and with a professional computer person helping me bring it up. I saw the one about the leaf blower. And I don't know if you saw it, but to me, I thought it looked pretty incriminating against the petition, one of the petitioners. You know, streets, yeah.
Do you know anything about that circumstance other than you saw the video later?
On the leaf blower? Okay, I do know something. I noticed, I think on that day, that the leaf blower looked like it might have started up by my handicap ramp, because all the needles were blown off there and on my driveway some. And I didn't have a view of what happened in what one of the petitioners started filming. I didn't have a view of that. That's all I can say on that. But I did see what I saw in the video.
May we have a chance to respond?
She's not a witness.
Your Honor, I feel like this is my turn, and this is probably my one and only chance. I excuse me. Pardon me, Your Honor. I have copies of all these false accusations against me. Now, I also, at the same time, I feel like if I start to respond to them, then that's just like it turns it into a bickering thing between them and I. So I really, Your Honor, I'm scared that if I do that, that it'll be considered bickering. But I do have definitely. I hoped you would ask me questions about any of them, because I do have a logical explanation for all of them there, and I don't. So I guess I'm going to leave it at that, because unless I hope you ask me questions, but I don't think it's your job to. But I don't think. But I'm real scared that if I start to try to defend myself on these, that it will be like I'm doing exactly what I'm not supposed to do, and I know what I'm not supposed to do, and I'm not a danger to anybody.
Yeah.
And I know how to handle myself, because I had a really good teacher in domestic violence, and I've been doing that. I've been using the tools that he gave me taught me to handle myself accordingly, and there's no danger to anyone from me as far as violence. That's not going to happen. It's not. I wouldn't.
Yeah, Mr. Davies, I get what you're telling me, that you don't want to be, characterized as a person who's dangerous or poses a risk to others.
Characterized as one thing, but it's just that the thing is no matter what anyone says or does to me, I'm not that man. I'm not going to hurt anybody.
I get that that's important to you.
Therefore,
to put out to the court, so that I understand that. I get that.
Yeah.
But I guess what I'm trying to, tell everybody and sort of convey here is that I've kind of got a narrower focus than that.
Yes. So I want to keep it narrow also.
That's why I'm, trying to get the focus more sort of directly on the allegations that have been put forward by the petitioners.
Yes, and I would like to respond to those. In fact, I need to, don't I?
Please, yeah.
Oh, okay. Yes. So, the allegations of the petitioners, from what I understand of the noise ordinance, sir, they've been saying I've been doing stuff like midnight and stuff like that, like midnight and late at night. Well, those times I haven't been there, and I haven't realized one single incident where. And I'm not trying to do this noise facetiously. I'm not, but and so I haven't realized one single time. It seems like to me like they're trying to get me in trouble for, I don't know, just to get rid of me. If this is their way of getting rid of me, well, I really need to be there to help my mother. And by the way, I do the pressure washer's no longer there. I'm trying to resolve this like peacefully without any confrontation with them. I like them, and I don't want to be. I don't need. I'm saying this through the court, please, not one only. I don't wish to have any kind of. I don't wish to harm them, and now I realize that, Your Honor, that one of the petitioners is pregnant, and so this is my one only chance. So I would wish to congratulate them through the court. I don't want to.
Yeah,
I
he
don't
puts it
want
on
to
the
harm
record.
them. I don't.
Oh my goodness, neighbors.
I don't admit
they're not a good fit for each other.
I didn't know that I was. I don't admit guilt because I didn't feel I was guilty. So, anyways, I guess that's all I have to. I really don't know how to defend myself on this. On each and every one of these, because as far as I know, they're accusations. I'm not. All these things with me peering in windows and that kind of thing. It's natural for someone to look around them while they're walking or riding their bicycle, and I'm definitely not trying to look in their windows. I don't want to, and I'm not. I'm at my mother's house a lot, and it may appear that way, but that's not what it is. I'm not that man. I'm not at all.
Wow.
So
that is a lot.
I understand what you're saying. I do.
These people just need to move apart from each other. Everyone needs to move.
It's not difficult to make a ruling in this case. I mean, I want you all to understand that I'm not here to enforce noise standards that are promulgated by various agencies in the state or the city.
This is
this isn't about.
Yeah, this is about
you're not accused of any criminal behavior. These accusations that have been brought by the petitioners.
Yeah.
This isn't a criminal context. So it's not a question of whether you're guilty of any kind of a crime.
Yeah.
And
a danger or not,
able to regulate or police the rules of a neighborhood, like a neighborhood association.
Yeah, I don't expect that.
Like that. There's often confusion about that when we're here at anti-harassment.
I don't expect that.
So, the question is whether there's been a course of conduct directed at these petitioners that seriously harasses, alarms, annoys them, and whether they suffered substantial emotional distress and whether or not that was reasonable under the circumstances.
Yes, Your Honor.
And the evidence that they put forward to the court in terms of their testimony, in terms of their declarations, and what they say happened establishes that. It's clear to me that, this is using the machinery, the noise, the times it's being used, the circumstances under which it's being used is absolutely detrimental to them. And that's before I consider the allegations about peering through the windows and things like that. Yes. That would give any reasonable person the belief that they're being targeted by a course of conduct that's designed to annoy or alarm them, and it's doing that. So that, I think, is established. The question is now that it is established is what to do about it. I'm not going to put an order in place that says your mom can't have you come over. But there is going to be an order put in place. You got to leave these people alone. All right, because what has happened to them is seriously annoying and harmful to them, and has caused them serious emotional distress, and they're entitled not to have to live like that. Now, you, Mr. Davies, may be able to resolve this yourself just by being more mindful of that.
Yes,
it's not an excuse that you didn't.
I fully intend to do that.
That you didn't know that they were being alarmed by it, although it's kind of hard to believe because
I didn't catch what you just said.
I
didn't catch what you just said, Your Honor. I apologize.
So I am issuing an order that's going to require you to stay away from them and not to continue any of these acts against them.
Does that mean I can't work on my mom's house?
No.
Your Honor, can we keep a distance requirement so that he cannot be on the side of her property that does peer into my window?
I don't have the ability, now, no crosstalk in the courtroom.
Understood.
Right? No, and because the reason is that I don't have a jurisdiction, this court doesn't have jurisdiction to restrict the way he uses real property.
From our property.
But he does have to stay away from you.
No more riding the bike up next to them and looking at them as you drove by. No more peeking in the windows. No more using the pressure washer every time they try to sell something on Craigslist to try to interrupt the deal. Those things are all out of the acceptable range of fun activities to do. For those of our friends who are up in Thurston County, Washington, please tell me this isn't every neighborhood. Please tell me this is the exception and not the rule. Oh my goodness. And I am so blessed to have good neighbors. See, the neighbor just next to us bought the house, came here from Australia, bought the house, he and his wife, one young child, and promptly started remodeling. Put up scaffolding next to the house, a couple sets of scaffolding so we can paint the outside, and then immediately bought another house in Oklahoma and moved. Didn't sell this house, but we have a quiet neighbor with a huge lawn that abuts ours. He lets our kids play in that area. We occasionally mow his lawn for him, and then once or twice a month he'll come back over and paint another piece of wood. Great neighbor, good guy. Miss their family, but then we have my other neighbor KR, who is like a personal bodyguard.
This order will be in effect for the next year.
Don't try him, because he will.
November 4th, 2025.
He'll put you in a pine box in a hurry, and has the means to do so. So he watches our back on that side.
To be clear, that this order is personal in nature. In other words, it protects the individuals of the petitioners, and it doesn't regulate property use. All right. So I know your great concern is that you can go over to your mother's house and help her. You can. There's no restriction on doing that.
It's not my only great concern, Your Honor. My great concern is also following the law. And I respect this court completely.
Fine, as long as you do that.
Yeah.
Your Honor, thank you for hearing me.
You're welcome. So
now get it on my court.
Order has been signed. The clerk has got it. We'll file it, and it'll be available to everybody from the court's records at any time. Okay.
Now, pack up and go. Wow. My other neighbor is a pastor in his church. He does have people come over and mow his lawn for him occasionally, but
next
great
case
that way.
Is going to be Harmon and Harmon versus Sprigg.
All right, that was interesting. Thurston County, Washington always delivers when it comes to just things that are a little different. Let's see what's 4 up to. Is 4 live? No. 1 live? No. 2 live? No other Thurston County stuff, but it's early there because they're on the West Coast. Oh man. A lot of explaining that wasn't necessary. Very patient judge. Actually, he's a commissioner. He's not a judge, but very, very patient. But I guess that app is the secret. I downloaded the app just in case I do get some bad neighbors at some point, because apparently you can just go to court and with this, what is it called? It's NIOSH-SLM. It's a really catchy name for an app, but it's a sound level meter that, let's see, testing 1 2, testing 1 2 3, testing. Welcome to the Court of Public Opinion. I talk at about 50 to 60 decibels. When I get really excited, it can go a little higher. The goats, we did the test on the goats. The goat, Christmas goat, comes in at 100 decibels, which apparently I should probably have ear protection for if we have a very goat-worthy stream. But the other goat is my quieter of the two goats, who is like the library version, and he comes in at 95 decibels, which is a little bit quieter. Kim R. checking in from the cruise ship. Kim, I'm jealous. I'm jealous. Should we measure the hump day tomorrow? Let's do that. Let's measure the hump day, y'all. Remind me to do that. We'll take a peek and see how we do. Why am I not surprised this app excites RA? Well, he had me at free. He had me when he said it was free. Although the OSHA stuff, that OSHA is occupational safety. This is literally work environment rules. I realize that when it comes to hearing protection, things like that, it can probably apply in the home, but you need different. You need like town council and city rules instead of OSHA rules for your case. But the judge accepted it. So it's been very rough. Oh, bummer. Like so rough, like the videos where the furniture is moving back and forth, and everyone just stays in their cabins and are not well. Red Pen, check the P.O. box mail today. Okay, I checked this morning, right before I went out and did a civic duty. But I took my kids with me. We checked the mailbox. I don't know where it came from, but we got 2 pickles, and they're cat kicker. Pickle kicker. I'm going to say this wrong, and it's going to be bad, but it's a pickle kicker for cats. It's like a catnip-filled cat toy in the shape of a pickle. I got 2 of those. Thank you. Red Pen, thank you. We have called the cat. We're waiting for the cat to show up, and my kids are super, super excited to see if the cat plays with it. Our cat does like to lay on his back and scratch things. Usually your hand is his preferred method, and because he is an outdoor cat, he has full claws. I mean, like talons. Usually cats have claws. Ours have talons, and so we anticipate being able to get him to play with it a little bit and see how it works. But thank you, Red Pen. You didn't read what they said on them. My kids took them right away. It said something about a big deal, or I'll have to go look because it has something written on one side, but I cannot remember right now. I can tell you the catnip is quite potent because of that. They're in the entryway, not in the house. They have some. They're powerful good. I'm sure the cat will be able to find it for sure. They're commercial. They were. Sorry, cat on Halloween, real cutie. I like him as well. He's a nice cat. My cats love catnip. Yes, that's basically how it goes with ours as well. All right, checking back in with, let's see, Mr. Judge Fleischer, possibly. He's on a little break right now. Florida Fifth Circuit Court of Appeals. I've never seen this guy before. What's this?
During that 9-month span, when there was ownership of the company, companies that should not have taken place as part of the merger agreement, there was arguably damages in the amount of $1.4 million because they took ownership when they were exclusively prohibited from doing so. Now, I want to be clear.
Okay, that sounds like business law, which is interesting, and it's probably very pertinent to them, but might not be fun for us to listen to. Let's see. Judge Simpson is currently on break. Let's see, we have... Oh, wow. Where is this guy from? I'm trying to see, just 1 second. Only I can see this right now. Jefferson County criminal, John Stephen Jr.'s personal. He's got a massive "do not record" in bold on his stream. So we'll give him a little privacy for that. He doesn't want us to record that. Thurston County, that was the old one we just watched. Let's see if Judge Kirkham's doing anything here out of Michigan.
Thing to tell me as it relates to the plaintiff's moral fitness.
Yes, as I said, she's diagnosed with bipolar and she has diagnosed with PTSD. So her mental health is not at peak level, I should say.
Oh, okay.
Um,
what can you tell me about the homeschooling community record of the children?
Oh, they go to Valley View. It's an excellent school. I work with them. I've been sending them to their school since they've been born, pretty much. The community, we live in
wait till they're
like a
old
nice,
enough, but-
quiet community. There's no crime over here. It's very peaceful. I'm not gonna lie. It's really quiet. The school neighbor that they go to, their neighborhood is really quiet. There's a lot of activities around where they can go to. Like we have like multiple parks over here. We have a water park over there. Let's see, the library events. We have a lot of events going down by the church. There's a lot of things to keep them preoccupied.
Okay.
Is this a divorce?
If in fact you were granted custody of the children, are you willing to work with the plaintiff concerning times that she would have the children with her?
I've attempted that, but I would like that's why I'm asking for a court order because I continue to try, but when she gets upset, she just refuses to send the kids, or sometimes she refuses to get the kids back. So that's why I was looking for something like in the court order, like where it's like ordered that we gotta do alternating weekends, holidays.
Okay. She had mentioned some instances of domestic violence. Was there domestic violence in your household when the two of you were together?
No, sir, there was no domestic violence. There was a lot of yelling and screaming. We did argue. That's why I had to split it up. But that's why there's no record of domestic violence. I've had the cops called on me multiple times, but then they get there and find out nothing happened. I've had to call the cops on her so we can split it up. But like domestic violence, no.
Yeah, I think we might bail on this one.
Anything else that you'd like me to be aware of?
Wanted to hear the other side, but
not at this moment, Jan.
Okay. I see. I guess, Miss Daniel, you have an opportunity to question Mr. Daniel, but I see it's close to noon. Are you going to have a lot of questions for him, do you think?
No, I don't have nothing. I have more to say, though. Like I said, I just thought of some more.
Okay. Why don't we do this then? You got more to say, and we'll probably do some more. Why don't we take a break for noon? I know you've only been going for about an hour, but we've been going since 8:30. So we'll take a break and then come back at 1:30 and start up.
Okay.
Okay?
Yes,
All right,
sir.
thank you.
Okay. So we'll see.
We'll see you as you head out. That one's out of Michigan, if you couldn't tell. Let me run back to the bottom corner where I belong. It is lunchtime. We are getting, she's got a rebuttal. Yes, she's getting a rebuttal in. I thought of some more to say. Got some things to complain about. Why is that on? Wait. I have a political ad playing on my phone right now that it's loud. Wow. Very long. Oh my goodness. Okay. Is it all the way down or off? Or just answer the phone and push the number 1 so it'll get us off their list. Sorry, there's a political ad that's like playing on loop with like different people's voices constantly. And it's on like full volume onto my answer machine in my office. I don't know why. It's never done that before. Thank you. Thank you. Holy cow. That was wild. So we're gonna make lunch. We were in limbo for a little while. I couldn't turn it on because it's gonna play political ads, and that's not good. We're gonna go to lunch. We're gonna come back. We're gonna keep doing a little court hopping. We are getting ready to announce our next case that we're gonna follow. Not ready to announce now. There are a couple big cases going on out there. Some of the fact patterns are not good for us. So we'll check and see. We're working with Trial TV Live on some upcoming stuff as well. So we're not covering Craig Lewis in South Carolina. No. Grizzly True Crime is a good option there. Trial TV Live, it's going to, I think, cover that one. Or maybe they're covering Iowa. I don't remember. But there's some options there for you there. We will see you on the flip side. Tonight when you go home, please hug the people you love. Smile at someone. Make their day just a little bit better. And please stay safe to go live again this afternoon for lunch. We might look at some documents as well. So there's some things coming up in the Brian Koberger case that we might be looking into. Some filings. All right, have yourselves a wonderful lunch. I'm going to have a salad to make up for the Mountain Dew I had this morning. So, it'll be good. All right, we'll see you guys this afternoon. Bye-bye.